Mr. Sweat. I believe we're here for sentencing. With regard to the indictment 47I-151049. Does either counsel or the defendant wish to address the court at this time?
Your Honor, thank you. Before we proceed with sentencing, I believe there's a motion that Mr. Sweat, although raised in chambers, I think wanted to address this morning. And speaking with Mr. Musha prior to walking in, it's my understanding he wanted to place that motion on the record as well, even though we issued it in chambers.
I see no reason for that.
No, and for the record, Your Honor, at this time, that motion is being, I guess, withdrawn by Mr. Sweat.
I'm sorry. The motion is withdrawn?
Yes.
Very well.
Thank you.
You may proceed. Mr. Webb.
Thank you, Your Honor. The people have reviewed the pre-sentence investigation report, Your Honor, that was prepared by Seneca County Probation Department as well as Clinton County Probation Department. On the date that the defendant entered his plea, Your Honor, he entered his plea to the 3-count indictment, which consisted of 2 counts of escape in the first degree and 1 count of promoting prison contraband in the first degree. The sentences that the court could impose in this matter is a 3.5 to 7-year indeterminate sentence, Your Honor. Those sentences would be imposed consecutive to the life without parole sentence that Mr. Sweat is presently serving, which he received on or about September 24, 2003, which was a life without parole for his conviction by plea to murder in the first degree. Your Honor, we would ask the court to impose that maximum sentence upon Mr. Sweat this morning. We would also ask that you impose fines and surcharges subject to your discretion, that the defendant would also be required to pay a DNA sample. There's DNA already on file, so the law requires him to pay the fee as opposed to give another sample. And lastly, Your Honor, the people are asking the court to order restitution in the amount of $79,841, and that is the monetary amount that the New York State Department of Corrections incurred as a result of repairing the prison cell walls, the interior portions of the facility that Sweat and Matt had both destroyed as a result of their escape. It also includes the repair and replacement of the steam pipe on the inside and the outside of the facility, which were also caused by Sweat and Matt during the escape. Your Honor, this escape in and of itself obviously caused trauma, caused anguish, caused fear to the citizens here in Clinton County, and not only in Clinton County, but Franklin County, Essex County, New York State, and probably the United States, while these 2 men were out for the time period between June 6 and June 28, 2015. And as a result of that, the expenses that the state incurred and that fear that was set in, I think it's very important for this court to impose the maximum sentence, even though it would be imposed on a life without parole sentence. There's really no difference in a situation like this whether the defendant is serving a life without parole sentence, whether the defendant is serving a 10-year determinate or 10 to 20-year sentence or a 5-year sentence in state prison. That a crime was committed, that the defendant committed that crime, the defendant admitted to committing that crime, and that a just and proper sentence needs to be imposed as a result of that. And that is one of the reasons why we prosecuted this case. To also send that message out to any inmate, whether they're at a local jail or at a state facility, that here, at least in Clinton County, they will be prosecuted. Thank you.
Thank you, Your Honor, and good morning. First, I would note that unlike Mrs. Mitchell and Mr. Palmer, my client has taken full responsibility for his actions. That at Mrs. Mitchell's sentencing, she showed very little remorse. And it should be noted that Mr. Palmer is still denying all responsibility for his role in the prison escape. But Mr. Sweat has taken the full responsibility by pleading guilty to the entire indictment. And that is all 3 counts that were lodged against him. Secondly, I would note that Mr. Sweat has cooperated with the IG's, the Inspector General's office. He's provided very useful information to the Inspector General's office, and that should be noted for the record. Mr. Sweat, he will continue to cooperate with the IG's office if the cooperation is still needed. It should also be noted for the record that after Mr. Sweat was shot, he spoke with law enforcement agents while he was in the Albany Medical Center. And Mr. Sweat revealed to those agents that there's a point in time when Mr. Sweat and Mr. Matt were on the lam, and Mr. Matt threatened to take hostages, to kidnap people, and kill people. And it was Mr. Sweat who talked down Mr. Matt from doing that. So I would say that Mr. Sweat saved some lives. There's another occasion when Mr. Sweat and Mr. Matt were on the lam, and Mr. Matt, he had a shotgun. He pointed the shotgun at a law enforcement official, and Mr. Matt was going to shoot that official, but Mr. Sweat stopped him from doing that. So that should be noted for the record. As far as any fines, as far as any surcharges, as far as any restitution, we would object. And the reason is Mr. Sweat is serving 6 years in the special housing unit, the SHU, and while he's in the SHU, he does not receive any commissary whatsoever. Once he is eligible to get out of the SHU, in 6 years, Mr. Sweat will be eligible for what's called grade 3 work. And it's my understanding, based upon the rules and regulations of the Department of Corrections, that a grade 3 work gives Mr. Sweat $6 per week. And it's my further understanding, based upon Department of Corrections rules and regulations, that 20% of that salary, so to speak, will be taken out of the $6 per week and applied to any order of restitution or fines and surcharges. So that is $1.20 per week that will be applied to any order of restitution. So this will not be paid off in, I did the math, but it's 1,029 years. So, Mr. Sweat, he has no resources whatsoever, and Mrs. Mitchell, she has a pension, and Mr. Palmer, I believe he'll be eligible for Social Security, and he'll have a pension of his own. So I believe that the order of restitution is better placed on Mrs. Mitchell and Mr. Palmer. And lastly, what I would note is I have spoken to my client. He is remorseful. He does apologize for his role in the prison escape. He apologizes for the trauma and for the fear that he put on on the state of New York and the county of Clinton. And that's all I have to say. Mr. Sweat may want to say some words.
Mr. Sweat, anything you wish to say?
Yes, Your Honor. I would like to apologize to the community and the people who felt the fear and felt it necessary to, leave their homes or their community because of the escape. That was never my intent, and I deeply apologize for that, Your Honor.
The court has read the pre-sentence report, and I thank the Seneca County Probation Department as well as the Clinton County Probation Department for putting together a report that gives some insight, I believe, into this situation. For approximately a month or so, this community was in turmoil. A number of people were exposed to danger. The officers and correction officers were placed in harm's way because of Mr. Sweat's act. It's evident to me from reading the report that Mr. Sweat is not stupid. He's intelligent, articulate, and understands what has happened to him and what he's done. He has, however, made stupid choices, beginning very early in his life. In 1993, to present. One of his more stupid decisions was got him convicted for murder in 2002. For whatever reason, other than stupid decisions made in January of 2015, when he joined forces with Mr. Matt to try and escape from Clinton Correctional Facility, it was another stupid decision. It was an act of boredom or opportunity. And the pre-sentence report adds another dimension, a belief or an attempt in some feeble way to point up the shortcomings of the correctional institution. I don't know what you were thinking at the time. I know what you're thinking presently, but I don't know what you were thinking at the time. And I find it difficult to contemplate that you felt escape would allow you to resume the freedom that you once enjoyed. Did you think that there would not be an all-out effort to bring you back into custody? I think it was another stupid decision, one that struck fear into the community that it didn't deserve, one that expended vast amounts of resources, money, and material, one that put hundreds of men and women in harm's way, and one that put you in the hospital with injuries you were still struggling with, one that killed a fellow inmate. And how would you term it other than stupid? You seem to indicate that you tried to escape to show the shortcomings of the correctional system, or as a protest of the treatment received from the correction officers. Aside from organizing an escape, I would ask, did you do anything to bring about a change in the facility by organizing or complaining or lodging complaints with regard to treatment or decisions made in the correctional facility? Maybe if you had expended the energy you expended in escaping to have reformed the program and conditions in the prison, it might have changed the outcome. It is all circumspect. You can attempt to elevate your actions to a cause, but I think it was simply another stupid decision. Sentencing you is anticlimactic, since life without parole, as they say, is what it is. I'm afraid rather perfunctory, since you are currently under an internal sentence, if you wish, of 6 years in solitary with loss of privileges. For acts, there are consequences, and unfortunately, you have had consequences aplenty. It is a sentence to this court that you be sentenced as a second felony offender. I don't know whether we filed or there has been filed a certificate of.
There has been, Your Honor, I believe.
The court has before it the information as to prior conviction of confinement, which indicates that Mr. Sweat has been convicted of crime murder in the first degree, a Class A felony in violation of Penal Law 125.271A in the County Court of the County of Broome, in the state of New York, on or about September 24, 2003. Does the defendant deny the existence of that conviction?
He does not, Your Honor.
Is he also confined to the detention facility, Clinton Correctional Facility, on June 6, 2015? Is that accurate?
That is accurate, Your Honor.
For the court will sentence the defendant as a second felony offender. On the first count of escape first degree as an E felony, Mr. Sweat is sentenced to a minimum of 3.5 years to 7, consecutive to your current sentence. On the second count of escape in first degree, a D felony, Mr. Sweat, you're sentenced to 3.5 years to 7, consecutive to your current sentence, and concurrent with the sentence on the first count. And on the third count, promoting prison contraband on the first degree, a D felony, you were sentenced to 3.5 to 7 years, consecutive to your current sentence and consecutive to your all sentences on count 1 and 2. In addition, the court will impose a mandatory surcharge of $300, crime victim fee of $25, a DNA data bank fee of $50, and restitution of $79,841. Does either counsel or defendant wish to address the comments made by the court?
No, Your Honor, thank you.
Mr. Musha?
No, Your Honor.
Mr. Sweat?
No, Your Honor.
Stand adjourned. Defense remaining.
Everybody remain seated, please.
Yeah.
Have seats.
Is there appeal paperwork
I'm
coming?
just going to say notice of appeals to be signed.